Lascan Corla, I want to start by also welcoming the family of Shane O'Farrell to the Visitors Gallery this afternoon, his loving parents Lucia and Jim, and his sisters Gemma, Amy, Pia and Hannah. Lascan Corla, when Shane O'Farrell left his home in Carrickmacross on the evening of the 2nd of August 2011 to go on a cycle in preparation for a charity triathlon, he had his whole life ahead of him. At 23 years of age, Shane had secured a law degree from University College Dublin, had just completed his Masters in Law at Trinity College Dublin, and would no doubt have proceeded to commence a professional career that would have been as distinguished as his student career. That life was never lived because Shane was killed that evening. His loss was incalculable. His family's was interminable. I know how much pain the O'Farrell family have gone through since they were informed that day of Shane's death. There is nothing that I nor the Irish government can do to alleviate that pain. What I can do, however, is record how the justice system that operated at the time exposed Shane to a threat to which he should not have been exposed. For many years, the O'Farrell family have sought a public inquiry. In fact, this House voted on the 14th of June 2018 and the 10th of July 2024 for the establishment of such an inquiry. The Seanad voted for one on the 13th of February 2019. The purpose of an inquiry is not to administer justice, but to reveal and report on facts that are of public importance. Many of the facts associated with Shane's death have already been established, mainly through the indefatigable work of his loving mother, Lucia. We could spend many years inquiring into these facts, facts that are already known, in the hope or expectation that a chairperson of such an inquiry would report them in a manner sympathetic and favourable to the facts as presented to me by the O'Farrell family. Lascan Corla, I need neither more nor further entrenchment of those facts in order to face up to my responsibility as Minister for Justice and the State's responsibility for failings in our system that exposed Shane to danger on that fateful day. It is part of the heavy burden that I carry as Minister for Justice that I must confront these failings in our criminal justice system. I do not need to wait for 5 years for an inquiry report to tell me about those failings. I know them already. I do not need a report to force me into Dáil Éireann to give the apology to the O'Farrell family that I humbly give today. The purpose of inquiries is twofold. First, to establish facts, and second, to effect consequences that derive from those facts. We have many of the facts. I now want to proceed to the consequences. Primary responsibility for Shane's death rests with Žygimantas Griciuskas, the Lithuanian man who, having been stopped by the Garda drug squad an hour before Shane was killed, drove the car that struck Shane from behind. He failed to stop and remain at the scene. Subsequently that night, he hid his vehicle away from his home. When he returned to his home that night, he told his wife that he had knocked someone down, yet they both then went to bed. Neither of them called emergency services. The driver was prosecuted in February 2013 for dangerous driving causing Shane's death. He was acquitted of that charge by direction of the trial judge. Unfortunately, a lesser charge of careless driving was not open to the jury. Prior to Shane's death, Žygimantas Griciuskas had repeated interactions with the criminal justice system, with his first conviction in Ireland occurring in March 2008. His repeated offending and the State's response to his consistent breach of court orders and sentences merits repetition before this House. It is an illustration of the havoc and, as we know, tragedy that can derive from the actions of a recidivist offender who is not held to appropriate account by our criminal justice system. These are the facts, Lascan Corla, that we know about his criminal behaviour in the 24 months prior to Shane's death. We know that on the 27th of January 2010, he was remanded on continuing bail in relation to 4 offences. having previously been granted bail for another offence on the 28th of August 2009. On the 12th of May 2010, Grudzinska was charged with 2 theft offences and was sent forward for trial on indictment to Monaghan Circuit Court. On the 9th of June 2010, Grudzinska was charged before Carrickmacross District Court with 4 offences of possession of heroin. He received a 6-month concurrent sentence for 2 of these convictions and a 3-month conviction for 1 other, with the final conviction being taken into consideration when imposing sentence. On the same day, the 9th of June 2010, he filed an appeal against these convictions and lodged €1,000 in lieu of surety. This resulted in him being released from custody on that day. The first failing by the state arose here because the appeal documentation was wrongly filed, with the result that the appeal was never processed within the District Court office in Monaghan. The appeal should have been recorded on the criminal cases tracking system that is operated by the court service. It wasn't. Had it been recorded, the appeal documentation would have been produced and the file would have been sent to the Circuit Court so that an appeal hearing could be arranged. The failure to record this appeal meant that there was never a determination as to whether his 6-month sentence for the heroin offences should be activated. Instead, by simply lodging an appeal on the day of his conviction, Grudzinska avoided ever having to serve the sentence imposed. It must also be recalled that on the same day, the 9th of June 2010, Grudzinska also faced 4 other charges before Carrickmacross District Court. He was charged with theft and also charged with theft and receiving, for both of which he was sent forward for trial to Monaghan Circuit Court. Between the 9th of June 2010 and the 11th of January 2011, Grudzinska committed 10 further offences relating to road traffic offences, possession of heroin and theft offences. 4 of these cases came before His Honour Judge John O'Hagan at Monaghan Circuit Criminal Court on the 11th of January 2011, and the Circuit Court judge directed that they be adjourned for 1 year until the 11th of January 2012. The judge said that if Grudzinska kept out of trouble and did not commit further offences, the judge would adopt a lenient approach. However, if he got into further trouble, he was to be brought back before the court and a custodial sentence would be imposed. Lascan Corla, it is worth reciting the exact words used by Judge John O'Hagan on that day. He said, quote, "If he does get into trouble again, it'll come straight before me, anywhere on the circuit, wherever I may be. You might even get a trip to Donegal, wherever it may be. Bring it in front of me, and I will deal with Zygomantas Grudzinska. I'm giving him this chance and this chance only. If he messes it up, so be it. And I can assure you, Zygomantas Grudzinska, if you do mess this one up and you do get convicted, you will be going to prison. Not you might, you will be going to prison." Lascan Corla, this is where the second failing of the state occurred, because between this date of the 11th of January 2011 and Shane's death, Grudzinska was charged with and/or committed 11 further offences, yet he was not returned before Judge O'Hagan. On the 16th of February 2011, Grudzinska was brought before Carrickmacross District Court on another drugs charge. He was convicted and sentenced to 6 months' imprisonment. Again, he appealed his conviction, lodged €1,000 in lieu of surety, and was again released. On this occasion, his appeal papers were properly lodged. The failure of the state was that this conviction should have been brought to the attention of Judge O'Hagan, who had very clearly indicated that any further offences should be brought to his attention. On the 23rd of February 2011, he was convicted of 2 counts of theft. On the 8th of March 2011, he was convicted of another theft charge before Cavan Circuit Court. None of these convictions were brought back before Judge O'Hagan. In fact, he was also arraigned on that date for another single theft charge that had been sent forward on 17 December 2010 from Virginia District Court. The failure to notify Judge O'Hagan was again repeated when Grudzinska was convicted of 5 theft offences committed over 5 days before RD District Court on the 9th of May 2011, resulting in a 4-month suspended sentence. Once more, this conviction was not brought back to the attention of Judge O'Hagan. On 11th of May 2011, he was convicted of speeding with no referral again back to Judge O'Hagan. On the 8th of June 2011, he was again convicted of a single drugs offence before Carrickmacross District Court and was fined €500. Again, this conviction was not brought back to the attention of Judge O'Hagan. It is also noteworthy that he received a conviction in Northern Ireland on the 15th of July 2011, and arrest warrants issued against him at that time were not executed. Lasceann Comhairle, the O'Farrell family believe, and I agree with them, that had those convictions on the 16th of February, the 23rd of February, the 8th of March, the 9th of May, the 11th of May, the 8th of June, the 15th of July, and or the 25th of July been brought to the attention of Judge O'Hagan, as he directed in his ruling of the 11th of January 2011, the likelihood is that Grudziuska would have had a custodial sentence imposed upon him on any of those dates. Had this occurred, Grudziuska may not have been at large on that fateful day on the 2nd of August 2011, when Shane was killed whilst on his bike. Between the 27th of January 2010 and Shane's death, Grudziuska was convicted of 30 offences. We know that these 30 offences he committed before Shane's death were committed whilst he was on bail, and we know that he was on bail for at least 6 offences on the 2nd of August 2011. Our criminal justice system at present requires, under Section 11 of the Criminal Justice Act 1984, that a person who is convicted of an offence whilst on bail should face a sentence consecutive to the offence for which bail was granted. However, the commission of an offence whilst on bail is not itself an offence, in the same way as failing to appear before a court in accordance with bail terms is an offence under Section 13 of the Criminal Justice Act 1984. Nonetheless, it is a condition of every bail bond that an accused person does not commit any further offences whilst on bail. The legitimate questions that the O'Farrell family have asked are why the persistent breaches of bail conditions by Grudziuska to the commission of further offences did not trigger a response under our criminal justice code, and why were consecutive sentences not imposed in respect of the offences he committed whilst on bail, and why warrants that were issued were not executed. On the 26th of January 2011, on the 11th of May 2011, and on the 25th of July 2011, Grudziuska breached his bail conditions when he was convicted of road traffic offences. None of these were brought back to the attention of Judge O'Hagan. More significantly, the 5 theft offences he was convicted of on the 9th of May 2011 were not brought back to the attention of Judge O'Hagan. In fact, the court hearing those theft offences was not informed of Judge O'Hagan's direction. Grudziuska was also charged with having no texts in his car on the 6th of April 2011, but this was not prosecuted until the 16th of November 2011. Lasceann Comhairle, it is clear that throughout this time, Grudziuska was ignoring the many different bail conditions set by the various courts. It is clearly the case that many of the offences committed by Grudziuska whilst on bail were summary offences. The broader question that needs to be answered is how our criminal justice system should respond to a recidivist offender who persistently breaks summary laws, and whether, even if the theft offences had been brought back to the attention of Judge O'Hagan, the judge would have had the jurisdiction through statutory power to remand Grudziuska in custody. In order to answer these policy questions, I have asked Senior Counsel Larkin Staines to assess our bail laws and make any recommendations he believes are appropriate, taking into account the requirements of constitutional justice and the impossibility of refusing bail to every person accused of summary offences. I have required that this report be finalised and presented to me within 4 months of his engagement. I have asked that he identify any necessary changes that need to be made to our laws in relation to bail and/or suspended sentences. This is not a report that needs to establish facts, since those facts are very readily apparent from the charges laid against Grudziuska in the year leading up to the death of Shane O'Farrell. It will not result in people having to invoke their in re haughty rights and lawyering up in a process that would inevitably take years. More importantly, it will not need to establish any facts, since the relevant facts are already known. This year, the Government will also be seeking the amendment of Section 53, subsection 4 of the Road Traffic Act 1961 in order to take into account one of the consequences of the trial of Oireachtas. As we are aware, he was acquitted by direction of the trial judge of dangerous driving. The jury was not, however, permitted to proceed to consider the lesser charge of careless driving. It has been the law since 1962 that where a trial judge directs an acquittal of a person charged with dangerous driving, they cannot then be found guilty of the lesser offence of careless driving. The option of the lesser offence is available with a jury acquittal of dangerous driving, and it's a serious flaw in our law that the option is not available in the event of an acquittal direction from the judge. I am pleased to say that the Minister for Transport, Darragh O'Brien, has agreed to ensure that Section 53, subsection 4 of the Road Traffic Act 1961 be amended in the next road traffic bill he will be introducing in the Dáil this year. This will be the second change to our law achieved as a result of the tireless campaigning of Shane's family. Section 17 of the Road Traffic Act 2014 was also introduced in memory of Shane and as a necessary correction of our law. It established a new indictable offence of leaving the scene of an accident where an injury or death has occurred. Last Corla, this review of our bail laws and the further proposed change to our laws that I announced today are a reflection of how the criminal justice system did not protect Shane O'Farrell. Our laws will be changed to reflect his memory. In light of the failings in the criminal justice system that I have outlined in this speech, it is incumbent on me, as Minister for Justice, to apologise to Shane O'Farrell and the O'Farrell family for the fact that the criminal justice system did not protect him as it should have. I do so apologise. However, we should also remember Shane not just because of how he died, but also because of how he lived and what his life may have been. Shane was a law graduate of UCD and TCD. He respected and obeyed the law. He was destined for a career in the law. Nothing I can do can realign that trajectory of a life stolen in its prime. We can, however, commemorate that life. I am honoured to announce, Last Corla, that the Department of Justice will fund every year a scholarship in the name of Shane O'Farrell that will be awarded to a student who distinguishes him or herself in the Masters of Law degree at University College Dublin. The Shane O'Farrell Award will confer on its recipients in perpetuity the honour of the excellence by which Shane lived his short but exemplary life. Last Corla, it is my sincere hope that what I have said today on behalf of the Department of Justice and on behalf of the Government of Ireland will provide some peace to the O'Farrell family. I hope that the review of our bail laws and the actions to be taken thereafter will help prevent other families having to suffer in the way the O'Farrell family have suffered. And I hope the O'Farrell family can take pride and comfort in the fact that Shane's memory will live on through this scholarship at UCD. Last Corla, I finish by saying something to the O'Farrell family that I know every member of this House will agree with. And that is that it is because of the work and tireless campaigning of the O'Farrell family that the memory of Shane O'Farrell will not be forgotten.